So just wonderful. Yes, it should be.
All right, the live stream has started. Welcome to the Cause Chambers West Garth Grand Final Moot. Tonight we have Matthew Singer and Jonathan Hull from Cause Chambers West Garth judging, and we have our two teams. So okay, all right. We'll hand over to our judges.
Great, thank you. Because obviously it won't necessarily be clear, I'm Matt and this is Jonathan. But let's start off. I'll take appearances, please.
May it please the court, my name is Moore, M-O-O-R-E, initials R-M, and I appear with my junior counsel, Mr. Kopp, C-O-P-P, initials J-A, for the plaintiff, Outback Events Proprietary Limited, hereinafter Outback Events. I will speak for 9 minutes and Mr. Kopp will speak for 10 minutes, and we reserve 1 minute for rebuttal.
Thank you very much. Defendants, you are on mute.
My apologies, Your Honour. If it may please the court, my name is Bass, B-A-S-S, initials H-G, and I appear with my junior, Shaw, S-H-A-W, initial K, and we appear on behalf of the defendant, Camel Caravans Pty Ltd, also known as Camel Caravans. I will be speaking for 9 minutes, and my learned junior counsel will be speaking for 11 minutes.
Thank you very much, defendants. Plaintiffs, the floor is yours whenever you're ready.
Your Honours, the plaintiff will make 4 submissions this evening. I'll be arguing submissions 1 and 2, and my junior counsel will then argue submissions 3 and 4. First, Outback Events is bound by the contract with Camel Caravans as the contract was duly executed. Our second submission is that Camel Caravans breached an essential term of the contract by not providing a luxury service. Our third submission is that Camel Caravans breached the Australian consumer law provisions relating to consumer guarantees and misleading and deceptive conduct. And finally, our fourth submission is that Camel Caravans ought to pay the losses claimed regarding future economic loss and loss of reputation, as only these appropriately place Outback Events in the situation as if the contract had been performed. Your Honours, I would now like to draw your attention to our first submission, that Outback Events is bound by the contract with Camel Caravans as the contract was duly executed. Your Honours, we submit the contract was duly executed despite the fact that only one director, Cersei, was signatory, pursuant to Section 126 of the Corporations Act 2001, a Commonwealth Act. Your Honours, may I please have leave to dispense with formal citations?
Yeah, that's fine. Thank you, counsel.
Thank you. In response to my learned friend's submission that 2 directors have to be signatory, we submit that Section 127, subsection 4 of the Corporations Act makes it clear there are ways for a company to execute documents other than those listed in subsections 1 and 2, specifically the operation of agency. Furthermore, Your Honours, we submit that Cersei had duly executed the contract in her capacity as an agent because she had express, implied, and/or in the alternative, ostensible authority. In regards to express authority, my learned friend submitted that Cersei did not have express authority as she did not have Camel Caravans' permission to execute contracts. However, if I can take Your Honours to paragraph 10 of the facts, Cersei had, in fact, previously executed contracts on Camel Caravan's behalf from time to time without Jamie's approval. We submit, Your Honours, that because Cersei had previously executed contracts without approval, it would be reasonable to infer Camel Caravans, through Jamie, had given express authority to Cersei to execute documents.
Counsel, if you're drawing an inference here, how is that express authority?
Pardon, Your Honour?
You said that it can be inferred from this conduct that she had authority, but we're dealing here in your submission with express authority. Is it permissible to create express authority through an inference, or must there be something in writing, for example?
Your Honour, we submit that express authority can be given either in writing or orally, and we're simply making a submission that that previously may have happened in the past. But if Your Honour, if I cannot convince Your Honour on that, we submit alternatively that Cersei had implied actual authority from the circumstances and the relationships of the parties. That Cersei was not an ordinary individual director, or that she was given authority through Jamie's acquiescence. Your Honours, we submit that again, pursuant to paragraph 10 of the facts, because Cersei had previously executed contracts without Jamie, the other co-directors' approval, executing this kind of contract fell within the usual scope of Cersei's authority, just as it had in the past. That executing such a contract is within her usual position and authority as an individual director for Camel Caravans, analogous to that of a managing director's customary authority. Alternatively, Your Honours, we submit that Jamie's conduct constituted implied authority by acquiescence. This is because there are no facts to suggest that Cersei has been appointed as an agent. Jamie would have known Cersei is executing such contracts, and Jamie has arguably communicated his consent through his conduct in allowing Cersei to continue to execute contracts without approval.
Is there anything specifically on the facts, counsel, to say that Jamie was aware that this was taking place?
Your Honour, there is nothing specific on the facts, but I was simply just trying to make an inference.
Certainly.
But we do submit, however, that Jamie allowing Cersei to continue to execute contracts if he had known, that is analogous to a board of directors standing by with the knowledge that a person is exercising authority that has never expressly been given. Additionally, Your Honours, or in the alternative, we submit that Cersei had ostensible or apparent authority through our actions in signing, organising, and orchestrating the contract. Your Honours, we submit that Camel Caravans in Jamie's acquiescence had represented Cersei had apparent authority through our actions. And further, we submit there was no need for Missandei to inquire or investigate whether Cersei had been properly appointed pursuant to section 129, subsection 3 of the Corporations Act. We submit that Cersei had held herself out to either be a managing director or an individual director who had been given power to enter into such contracts so as to constitute the requisite authority. For completeness, we rely on our written submissions as to the authority of the rest of the parties, Daenerys, Khal, and Missandei, as these have not been pleaded by the defence. Therefore, Your Honours, we submit the contract was binding between the parties.
Just before you move on, counsel, so just taking one step back, am I right in thinking that realistically, looking at the facts, the only thing that you can point to really, as a form of conduct is that paragraph 10?
Yes, Your Honours, the past conduct.
Yep, understood. Thank you.
Would it be okay to move on to submission 2, Your Honours?
Please.
So our second submission is that Camel Caravans breached an essential term of the contract by not providing a luxury service just as luxurious as Missandei's trial tour on 6th of March 2019, hereinafter the trial tour. Your Honours, We submit the term luxury provided in paragraph 1 of the restorations is ambiguous. The term is not defined anywhere in the restorations, the words preceding the term, nor can it be implied solely from the contract as a whole. Thus, in the face of this ambiguity, we submit regard must be had to the circumstances in which the parties contracted, so as to establish the factual matrix and to ascertain its true meaning.
Council, why do we not just in first instance look to the plain and ordinary meaning of the word? Why do we move to this test of this sort of subjective test, if you like, or this contextual test?
Your Honour, our submissions look to the specifics in paragraphs 4 and 5 solely as we believe that it gives more context to the decision.
What I'm asking though is that the test at law? I'll be clearer. Is there a test at law that you can offer me as to which one should come first?
Your Honour, we submit the test at law is Cadelpha, in that in the face of ambiguity, we look to surrounding circumstances to establish the true meaning. I could run through a plain or ordinary meaning first, if Your Honours would like.
Look, let's stick with the order of your submissions, but you are going to address plain and ordinary meaning?
Yes, Your Honours.
Yeah, perfect. Then proceed as due course.
So if I could take Your Honours to paragraph 4 of the facts. The purpose of Masande's trial was to see just how luxurious Camel Caravan's touring service was. If I could take Your Honours to paragraph 5 of the facts. Masande on this trial tour found extremely well looked after camels, saddlery that was bright and comfortable, and an engaging tour guide. We submit that it is these factors that establish the factual matrix and provide the true meaning of the word luxury in this context. This is because if I could then take Your Honours to paragraph 6, Masande had expressed how important it was that the July tour be just as luxurious, given the intended elite clients. And as Your Honours can see, Cersei then promised that the exact same luxury service would be given to the July tour customers. We submit that luxury is defined to include these facts, as evidence of these discussions can also be seen in paragraph 2 and 3 of the restorations, regarding this acknowledgement of the elite clientele and the provision of an informative tour guide. In the event that the court does not find that definition, we submit, contrary to my learned friend submissions, the restorations and plain ordinary meaning of the word luxury necessitated more than simply a camel service tour for up to 30 people within specified dates and a tour guide.
That's time.
Your Honours, could I please request an additional minute, perhaps a minute and a half, to finish off the submission regarding the plain ordinary meaning?
You can have 1 minute, Council.
Okay, thank you, Your Honours. We submit that even on a plain ordinary meaning of the word luxury, defined by Macquarie Dictionary as anything conducive to sumptuous living, usually a delicacy, elegance, or refinement of living, that Camel Caravans did not provide this. If I could take Your Honours to paragraph 12 of the facts, the experience of the July tour included unkept, thin, and listless camels, with saddlery that was dirty, frayed, and lumpy, and a tour guide that was hungover, rude, and uninformative. We submit, Your Honours, that this does not meet the definition of luxury as implied from the circumstances of the contract, those facts provided in paragraph 5, nor does it meet the plain ordinary meaning of the definition of luxury. Therefore, Your Honours, we submit the contract was binding and that it was breached, and Outback Events is therefore entitled to terminate the contract and claim damages. Unless I can be of any further assistance, Your Honours, that concludes my submissions with respects to ground 1 and 2.
Thank you, Council.
Thank you.
Whenever you're ready, Council, we're in your hands.
Your Honours, we thirdly submit that Camel Caravans is liable under the Australian Consumer Law for for their breaches of the provisions relating to consumer guarantees and misleading and deceptive conduct. These provisions apply because, firstly, both companies constitute persons under the ACL, and secondly, the contract was created in trade or commerce. To ensure I utilise the court's time most effectively, Your Honours, I'm going to focus my oral submissions on the latter of those at point 3.2 of our submissions on misleading and deceptive conduct. The first issue for the court's determination here is to identify exactly what constituted the misleading conduct in question. Cersei's promise that the exact same luxury service would be given at paragraph 6 was an express representation that was likely to lead a reasonable person in Ms. Sunday's position into error. It reasonably does so, leads her into error because of the following reasons. Firstly, we're told at paragraph 4 that this was the start of a business relationship, and therefore Ms. Sunday had no reason to suspect that Cersei wasn't being truthful. In paragraph 5, Your Honours, the trial tour that Ms. Sunday experienced in March was in fact provided at the standard of luxury that was required. She, and by extension Outback Events, were therefore entitled to expect Camel Caravans to be able to replicate that experience come the July tour. Thirdly, Your Honours, Ms. Sunday was pressured by Cersei to enter the contract almost immediately after Cersei had made that misleading representation. And fourthly and finally, Your Honours, the contents of the relevant document itself, that is the restorations contract, acknowledged the fact that these were elite clientele and that the same standard of luxury would be required in the July tour.
Does the standard of clientele play a material role in this, council? I mean, does it matter if it was, you know, a bunch of C-suite people versus your everyday person taking a travel? Is that material to the claim?
I submit that it does matter, Your Honour, because misleading and deceptive conduct is assessed by reference to the person at whom it is directed to, whether it's a specific identified person or the public at large. So the fact that Ms. Sunday had emphasised the fact that her clients were such elite international clients should be taken into consideration as to whether Cersei's representations were misleading. If I may proceed, Your Honour, to the next relevant point. Representations as to future matters, unless the defendant can adduce evidence to show that they had reasonable grounds to make that representation, it is deemed to be misleading by virtue of section 4 of the ACL. On the facts as they are provided, there is no suggestion that Cersei had reasonable grounds on which she could make the representation in March. And I anticipate that my learned friends might try and submit that there could have been some unforeseen losses or other type of extenuating circumstance which did constitute reasonable grounds to make that representation. But my response to these claims would be that they cannot be drawn on the facts as they are provided. Furthermore, even if there were reasonable grounds, it's still an issue for the court to determine whether in fact that conduct was misleading. And for the reasons I gave earlier regarding the nature of the dealings between the parties and the document itself, I submit that that question should be answered yes. Regarding damages, Your Honours, should you agree that Cersei's conduct was misleading, our client is entitled to receive damages for any loss or damage suffered because of the conduct. 2 heads of loss are presently being claimed: $600,000 for future economic loss and $200,000 for loss of reputation.
Just to clarify, counsel, is this loss also contingent on the breach of contract or just your ACL claim?
I'll go into breach of contract and general contractual principles in my next submission, Your Honour, submission 4. ACL is, as you know, a separate statutory duty and statutory scheme placed on the defendant. So, no, I would say that they're separate assessments as to how the damages are made.
So is there any, you know, presumably you're not trying to double dip here. So can you sort of run us through how that your loss sort of breaks down, just seeing as we're talking about it now?
Of course, Your Honour. So 2 heads of loss are being claimed. We've got $600,000 for future economic loss, being the 2 contracts, and $200,000 for the loss of reputation. The first thing to establish is that Cersei's conduct caused these losses, or was a cause, in that it materially contributed to them. It's not necessary to be the sole cause. So the inflammatory tweet posted by the IA Enterprise employee at paragraph 14 is irrelevant to that. The Outback Events decision to enter the contract was not passively suffered, but for the misleading conduct, they would not have entered the contract in the first place. And therefore, I submit that they are entitled to recover all the losses claimed, which includes the loss of the vegan beauty contract, as that inflammatory tweet, which caused the loss, would not have occurred but for Cersei's misleading conduct in the first place in making the representation.
Which is, other than that tweet, counsel, is there anything else that you can point me to on the facts that sort of makes that link between the loss of the follow-on contract?
Yes, Your Honour. In order to recover future expectation loss, which is what this is, future economic loss, it needs to be shown that but for the reliance on the conduct, the plaintiff or the claimant would have entered into a different contract, and that would have resulted in a profit for them. So regarding the vegan beauty contract, if we look at paragraph 15, it says, Vegan Beauty said they do not condone animal cruelty and stated they would no longer require their services. So from that, I take it to mean if that tweet hadn't been made, and the tweet was caused by the misleading conduct, then that contract would have gone on as it had in the past. And likewise for the IA Enterprise contract, if we look at paragraph 13, they said they're no longer going to require the services because of the disgraceful event. Moving to the issue of accessorial liability, Your Honour, I submit that direct liability can be established onto Camel Caravans as Cersei's conduct was engaged in on behalf of the body corporate because she was a director. I note that on behalf of in this context does not require express authority. It is enough that it's done in the course of the body corporate's affairs or general activities. Your Honour, do you have any further questions on that submission, or shall I move to submission 4?
No, look, you've only got about 4 minutes left, so let's jump to breach, shall we? The contract point.
Okay. We fourthly submit the amount of...
Sorry, I just realised, yeah, it's updated. You've only got 1 minute left. I lied.
Thank you, Your Honour. The amount of $800,000 is recoverable through general contract law principles in order to put our client in the position as if the contract had been performed. This must be qualified by 3 factors, namely causation, remoteness, and mitigation. We submit that the damage was caused by Camel Caravan's breach of contract because it wouldn't have been suffered but for that breach. The vegan beauty contract, while it also had another cause, as a matter of common sense, the initial breach of contract should still be regarded as a cause of the loss. Regarding remoteness, Your Honour, the principle from Hadley and Baxendale says it must arise either naturally from the breach or within the contemplation of the parties.
That's time.
That's time. Your Honours.
In the interest of fairness and that I blatantly lied to your face about how much time you have left, we'll grant you a minute to finish, please, counsel.
Thank you, Your Honours. Yes, so I submit that the losses suffered by our client either arose naturally or were in the parties' contemplation. Arising naturally means it must be not unlikely to occur. And here, the damage to the reputation would be considered as probable given the extent to which the luxury service had been provided. And alternatively, it would have been within the parties' contemplation that they would lose the contract. And paragraph 1 tells us that the company was renowned for its Outback events. So I submit that this should be something considered that was in the contemplation of the parties. And Your Honours, I'll rely on our written submissions in regard to the final factor, mitigation, in that there were no failures to take reasonable steps by Outback Events. Thank you, Your Honours.
Thank you, counsel. Just one moment, defendants. Right, thank you, counsel.
Thank you, Your Honour. There are 4 issues for determination before the court, to which our learned friends have raised. Whether Cersei had authority to execute the contract on behalf of Camel Caravans, whether there was a breach of contract, if the defendant has contravened the provisions of the Australian consumer law, and whether the plaintiff is entitled to the compensation sought. I will be submitting that Cersei did not have express, implied, actual, or ostensible authority. And I will also be submitting that no legally valid agreement existed between the 2 parties because of this, and that Camel Caravans did not breach any of the restorations in the contract. My junior will be submitting that none of the relevant sections of the Australian consumer law have been breached, and that the plaintiff is not entitled to the compensation sought. In regards to Cersei's authority, Your Honour, I submit that he did not have, that she, my apologies, Your Honour, did not have express actual authority. And the case under sections 127 and 126 of the Corporations Act, and the case I rely on for this, Your Honour, is Peterson and Maloney, reported in 1951 in volume 84 of the Commonwealth Law Reports at page 91. May my junior and I dispense with full case citations, Your Honour?
Yes, thank you, counsel.
Thank you. We submit, as per line 10 of the facts, as our learned friends had, Your Honour, that Cersei never was given approval by Jamie to execute contracts, which therefore means that she was not able to have express actual authority. In regards to express implied authority, Your Honour, this requires an agreement between the agent and the principal, as per Healy, Hutchinson and Braehead. As per line 10 of the facts, Your Honour, Your Honours, my apologies, no such agreement existed between Cersei and the company. Further, Your Honour, this did not occur in the normal role of Cersei's operations, as a single director does not have the authority to sign contracts in the normal conduct of their business, as was found in Healy, Hutchinson and Braehead. Further, Your Honour, in regards to ostensible authority, the Cersei, as director, never had the consent of the board or Jamie in executing contracts. And we would argue that this distinguishes this case from that of Healy, Hutchinson and Braehead, as in that case, it was found that the director did have, that the board and the other director, my apologies, of the company knew of the contract and therefore implicitly consented to it. In this case, Your Honours, we submit that there is no evidence that Jamie had knowledge of the contracts occurring. We only know, Your Honours, that no approval was granted. In regards to the, if Your Honours had no further questions about the authority of Cersei, I'll move on to my second submission.
Just one from me, counsel. In terms of what the other side have put to you, what do you think is the strongest point that the other side can put to you on this point?
Let me just have a look through my notes, Your Honours. I would say the strongest point that they would have is that potentially through the fact that the contract has been carried out, so like the money has been paid, could infer that Jamie and the board of directors knew of this occurring and let it happen. but we submit, Your Honour, that there is no evidence in the facts to state this. We only have that there was no approval. And so we submit, Your Honours, that this is enough to show us that there was no form of authority in any forms. Further, Your Honours, another argument they could have was if Masande assumed that Cersei had authority. And to this, Your Honours, we submit that there was never a representation by the company made. They never held out Cersei as having authority to Masande. He simply signed the contract.
No, that answers my question. Thank you, counsel.
Not a problem, Your Honour. I will now move on to the submission of breach of contract. We submit, Your Honours, that as Cersei did not have authority, no legally valid agreement existed. Further, Your Honour, we submit that none of the restorations of the contract were breached. A luxury camel caravan for 30 people was provided. And we submit that the circumstances and the facts fall within the plain and ordinary meaning of the word luxury. Now, Your Honours, the plain and ordinary meaning, we defined as having the habitual use of or indulgence in what is choice or costly, whether food, dress, furniture, or appliances of any kind, as defined by the Oxford English Dictionary.
Counsel, I'm not minded to get into a contest about whose dictionary is better, noting that you have used different ones. I'd like you to go to some submissions, because the other side spent a lot of time talking about this with reference to some of those items, which I think are in sort of paragraphs 5 and 6 of the facts.
Yes, Your Honour.
Did you have submissions sort of with respect to those sort of, specific tangible things that they made about the luxury?
Yes, Your Honour. So Masande expressed how perfect she thought Camel Caravans was for the planned July tour, and she told Cersei how important it was that it would be just as luxurious given the intended clientele. We state, Your Honour, that the material facts are that a luxury a camel caravan for 30 people was provided, and that a few of the facts here, Your Honour, in line 5. So the countryside beautiful. Nowhere in the facts is it stated that the countryside was not beautiful when the later tour occurred. Further, Your Honours, we would submit that the cost of the tour, $30,000, does constitute luxurious.
Counsel, that's, I beg your pardon, but that's a fairly perverse submission, in that essentially the contract price could have been set at anything, and it becomes all the more extortionate if the ultimate service provided is not luxurious. The key question I have here is what meaning can be given to the word luxury in light of these background facts? Are you submitting that luxury is ambiguous here, such that we can have resort to those things? Or would you prefer to base your submission on the plain and ordinary meaning alone?
We believe, Your Honours, that it is actually clearer to base our assumptions on the plain and ordinary meaning, and therefore apply the facts to the plain and ordinary meaning of the word luxury. And to this, I'd state that a tour was provided. It was provided in the same location to the same number of people, and that this would fall within what was provided for in the contract, and that the facts that were brought up, such as the saddlery being lumpy and the tour guide, are contextual features. As you had mentioned before, Your Honour, that is when expectations come into play. So the facts do not state where the employees came from. It's merely that they are an elite clientele that require a luxury service. And we would argue that these are factors that could be subjective. Was there any further assistance I could provide, Your Honours, in relation to this point?
I do have one further question, Counsel. If you remove the word luxury from the contract altogether, do you submit that what service was provided would meet that hypothetical contract where it was not intended to be luxurious?
Yes, Your Honour.
So in this case, if the word luxury is added on top of that, what does it add?
Your Honour, from our point of view, it means that you apply the plain and ordinary meaning of the word luxury to what was provided to show that it falls within what could constitute luxury.
I guess the thrust of my question, Counsel, is what was more luxurious about this tour than any other ordinary camel tour?
I would argue, Your Honour, that it would be that the countryside was beautiful and the other factors such as the tour guide being engaging. But if I can't assist Your Honours any further on this point, I'm aware we have also stated that the contract wasn't a legally binding agreement. May respectfully.
Council, you can wrap up if you've got some wrap up. We did grant each of the other speakers 1 minute, so you have 1 minute.
Not a problem. If I can't assist Your Honours any further in relation to the breach of contract, I would like to pass on to my learned junior.
Yeah, of course. Thank you very much, Council.
Thank you.
Thank you.
Thank you, Council.
Thank you, Your Honours. Referring to the plaintiff's written and oral submissions, the plaintiff submits that the defendant has breached the Australian consumer law, namely Section 18, misleading and deceptive conduct, Section 60, guarantee as to due care and skill, and Section 61, guarantee as to fitness for purpose. To establish that the defendant engaged in misleading and deceptive conduct, the plaintiff must prove that in trade or commerce, the defendant engaged in conduct that is misleading or deceptive, or that is likely to mislead or deceive. The defendant has failed to do this. Turning Your Honours to page 3 of the agreed facts, Ms. Sunday expressed how perfect she thought Camel Caravans was for the planned July tour, as discussed with my senior counsel. However, looking at paragraph 5 of the agreed facts, Ms. Sunday was taken on a short tour and found the camels to be extremely well looked after. The saddlery was bright and comfortable, the tour guide engaging, and the countryside beautiful. Moving on to paragraph 5, Ms. Sunday expressed how perfect she thought Camel Caravans was for the planned July tour. We submit, Your Honours, that as per the agreed facts, Ms. Sunday never expressed what about this service she found luxurious. The bright and comfortable saddle, the engaging tour guide, this was never expressed to Cersei during their negotiations prior to the contract being formed. Therefore, we are submitting that an expensive 7-day camel tour through beautiful Northern Territory was provided by Camel Caravans. The statement that Cersei made was on reliance of that fact, and therefore we are submitting that it was not misleading.
Council, just on this submission, can I draw your attention to paragraph 6 of the facts and the final sentence there? Just those opening words. If we disregard the word luxury altogether, the promise that was made was the exact same service. Could it not be suggested perhaps that that meant the same camels that were seen as discussed at paragraph 5, the same saddlery and the same tour guide, not just the same countryside? Whether or not that was objectively luxurious?
Your Honour, we submit that the agreed facts do not establish whether they were the same camels or not. There was a period of time between the March tour and the July tour. They could have in fact been the same camels. There could have been adverse weather that has affected the saddlery. The saddles could have been used from the point that the initial tour was taken and the second one. We are submitting it's quite unreasonable to expect brand new saddles every single tour ride. While I appreciate the point, we are submitting that as per the agreed facts, they could potentially be the same.
Thank you.
Your Honours, my learned friends did not orally go into their submissions in relation to breach of guarantee as to due care and skill or guarantee as to fitness for purpose. However, I note they are in their written submissions. Would you like me to summarise my submissions on these points?
You need not, counsel. I think you can direct further attention to the misleading or deceptive conduct submission, and particularly your counsel opposite submission as to the reasonable grounds point as to a future representation that was being made. Were there reasonable grounds in this case in your submission?
Sorry, could you rephrase the question?
Sorry, counsel, that was my fault for being unclear there. So junior counsel for the plaintiff has argued that there was a future representation being made here, or representations to future matters, that there were not reasonable grounds to support. Do you have a submission in response to that?
Yes, Your Honour, as discussed previously, as per paragraph 5 and 6, there was no, Masunda did not express to Cersei the representation, the exact representation in relation to the bright and comfy saddle that she found, for example. So there was reasonable grounds for her to make an assertion that she could provide the exact service. We submit that the sorry, Your Honour, the complaints are substantially personal opinions, and they do not describe the circumstances in which the plaintiff has misled the plaintiffs. There was reasonable grounds to make that, given they could be the same camels that came the same saddle. If I can't be any further of assistance to the court, I'm happy to move on to damages.
Please.
The plaintiff is seeking $600,000 for future economic loss and $200,000 for loss of reputation. The issues before the court is whether the plaintiff is entitled to compensation sought under the alleged common law breach of contract, and whether the plaintiff is entitled to the compensation sought under alleged breach of consumer guarantees or Australian consumer law. The purpose of common law breach of contract damages are to put the plaintiff in the position they would have been had the contract not been breached. The onus is on the plaintiff to show that the breach of contract resulted in some compensable loss. We are submitting the plaintiff has not established this. Outback Events is seeking $600,000 for future economic loss. This makes up $400,000 for the loss in relation to Aya Events and $200,000 in relation to the vegan company. While this loss may have been expected to be received, there is no guarantee of this income. We further submit that loss of reputational damages is not recoverable under breach of contract. This is a tort damage. If the court finds that the defendant has breached Section 18, I'm happy to move on to damages recoverable under the Australian consumer law if Your Honours have no questions in relation to common law damages.
Yeah, that's fine, counsel.
As per Section 267 of the Australian consumer law, a consumer may, by action against the supplier, recover damages for any loss or damage suffered by the consumer because of failure to comply with the guarantee, if it was reasonably foreseeable that the consumer would suffer such loss or damage as a result of such a failure. The elements the plaintiff ought to satisfy are whether the failure was reasonably foreseeable and whether the loss or damage was as a result of such a failure. Something is reasonably foreseeable if it is not far-fetched or fanciful. We submit that it is not far-fetched or fanciful, that a failure, that is, my apologies, Your Honour, we submit that it is far-fetched and fanciful that a failure to provide a comfortable saddle or clean-looking camels would result in a loss of reputation or a result in economic loss, especially having regard to the intervening act of the tweet, which was largely the cause of the $200,000 loss for the vegan company.
Your learned counsel opposite has submitted that it need only be a cause, relying, I believe, on March and Stromare. Can you overcome that submission in this case? If it need only be a cause, not the predominant or even the sole cause, how do you get around that?
We submit that the tweet has broken the chain of causation in relation to the but-for test. So we're submitting that, although we're submitting that it has broken the chain of causation.
Okay, and if that's in respect of the $200,000, has it done so in respect of the 600,000 as well, or is that a different sort of causation calculus?
In relation to the 400,000, we submit that that loss was not reasonably foreseeable, especially in relation to the alleged breaches are so small in comparison to the contract at large. Therefore, it is not reasonably foreseeable that something as small as how the saddle looked or how dirty the camel was would result in damages that could cause a loss of reputation or could cause loss of future economic loss. My apologies. While I note that I do have only 1 minute, I would like to bring your honours to
I'm sorry.
1 minute, counsel.
Sorry, I'd just like to quickly bring your honours to the attention of a decision of Moore and Scenic Tours. The facts of this case involve a class action where Mr. Moore booked an all-inclusive once-of-a-lifetime luxury cruise through Europe. And while this definition of luxury was printed in the brochures and in the flyers, this decision examines 13 different cruises, and the court in that case didn't establish that they breached due to failing to provide luxury. For example, in relation to cruise 10, the cruise was interrupted by strong currents. The plaintiffs had to disembark the cruise and go onto a bus. And then they were also provided onto a different cruise. And in that decision, the court found that these did not substantially deviate from what was originally provided for in the contract. This is a High Court decision, and we ask Your Honour
I'm sorry.
to rely on this binding
Yep.
authority.
I think we got where you were going with that one, counsel.
Thank you.
Thank you very much.
Your Honours, could I just have 1 moment to confer with some notes from my co-counsel? Thank you. Your Honours, I've got 4 points of rebuttal, but given the 1 minute time with which I can continue the court, I'm only going to mention 2. My learned friend in submission 2 submitted that the plain ordinary meaning of luxury should be utilised. and that the countryside was beautiful and the cost of the tour should be used to say that it did not breach the contract. I submit that on whatever interpretation this contract was ambiguous, that's evidenced by the fact that both parties had such different dictionary definitions, by the very fact that both parties are disputing the contract, and the elite clientele could be a subjective submission that my learned friend made. I would say, given how far the contract was stressed, that it should be construed as the standard of which they were international elite clientele. Your Honour, that was fully delivered. I've got one more submission, but I won't deliver it if I'm over time. Unless you'd like.
We're happy for you to leave it there,
Yeah, we're
councillor.
happy for you to leave it there, councillor.
Okay,
Thank you.
thank you.
All right, it's my understanding now that the conveners will separate us out to deliberate, but thank you to both sides for your submissions, and we will return with a verdict.
Thank you.
Thank you, Your Honour.
Thank you.
All right, thank you all to the competitors. The judges have just jumped out into the breakout room to deliberate. So that'll be another 10, 15 minutes and we'll reconvene.
Hi, everyone. Are we all back? You can blame about 2 or 3 minutes of our delay on our ineptitude with Zoom. But I assure you the rest of it was deliberation. We couldn't find the leave room button. But that's all good. Are the competition organizers there with us?
Yeah, we're here.
Okay, very good. The first thing we want to say is both teams need to be very proud of themselves. Putting yourself out there to do the mooting competitions, particularly the junior moot, is always really good for you to do. It's a really good experience, and you should be commended just as a starting point for putting yourself forward. With respect to the problem, I think as both teams are abundantly aware, the problem leaves a lot of scope to make arguments. You really have to get pulled in some instances to the extremities of the points. And I think both Jonathan and I felt that we were really impressed with the way that the teams used the facts in particular, particularly when you consider that, you only have 16 paragraphs of facts to work with. We felt that the teams really sort of pulled us through those, and command of the facts was excellent. We don't want to leave you in anticipation any longer. So we are pleased to announce tonight that we will be awarding the moot to the plaintiffs. So congratulations to the plaintiffs and commiserations to the defendants. But again, we want to convey that, other than the 2 minutes at the end, that entire time that we were away was deliberation, and there was a lot to go through. And certainly some of those points are very finely balanced, but tonight we felt that those fell in the plaintiff's favour. So commiserations to the defendants, but certainly well done, and you should feel very proud of your efforts tonight as well. We do have a few points of feedback. We've taken the approach just to go through some general feedback tonight, given that you've had some rounds where you've had the opportunity to get some specific feedback, but I'll let Jonathan sort of kick that off.
Certainly. So I thought on the whole, answers to questions were really well done. And that was particularly so in light of the fact that some of these issues are skewed one way quite clearly. I know particularly the defendants, you faced an uphill battle on certain issues, and I thought you did really well in the circumstances. So that's very highly to be commended. Potentially the only piece of critical feedback I would give on the whole is to pick your battles. For almost all speakers, there were quite a few alternatives that you were running simultaneously. And for the most part, you did devote more attention to the ones that were strongest for your case. However, there were a few occasions where we spent a little bit too much time on particular issues that I thought were potentially too difficult to have been argued in the circumstances. So I think in future, streamlining your submissions could really work wonders for your overall advocacy, particularly since it allows you to devote more time to particular issues. But I do want to stress again, Matt's comments. It was a very high standard moot, particularly for a junior competition. And I do encourage you all to continue mooting and to continue advancing your advocacy, because you're already very clearly naturally gifted.
I obviously echo those thoughts of Jonathan's, and I think look, realistically for me, the only point of feedback that sort of ties into what Jonathan said, which is part of picking your battles and sort of thinking about how you can maximize the time that you have is basically the pace in which you can get to the why factor. Why does this point matter? And I think, both teams tonight, we always got there. And that, that really, in some respects, is what makes the decision so difficult, because when both teams can get to the why of it, that's when we have to really sit back and look at, how to balance that in terms of which way it falls. But I think in both cases, teams would benefit from getting to the why a little bit faster, or at least giving us the why at the beginning. In most cases tonight, in most of the points, what makes the elements out is not controversial. It's how those elements are applied. It's whether something falls within it or not. And I think really characterizing that and telling us where the battle is going to be. So not only picking your battles, but telling us where the battle is going to be, and telling us why the battle is going to be there, and telling us why your side is better, and always sort of pulling it back to that point, is really what, you know, makes a really forceful and effective submission and leaves no doubts in the judge's mind. So, you know, it's, like I said, both teams got there tonight, and that's what made it such a difficult thing. But I think, yeah, just for the future, it's just always asking yourself that question, and, you know, taking that break when answering questions. Why are they asking me this? It always comes back to that. It is remiss of us actually to sort of introduce ourselves a bit more than just sort of these presences on your screen. So my name's Matthew Singer. I'm a lawyer here at Cause, and I've been here for a couple of years. Spent most of my time in the projects disputes team, and I'm just finishing up a rotation in the firm's Papua New Guinea practice, which is a bit more varied in terms of scope, sort of what they do. But a lot of my time at the firm has been dealing with Australian consumer law issues, contract law issues. So a lot of these issues are very close to home for me. In terms of mooting experience, I participated in a number of moots my time at university. One of them with Jonathan, actually, and that was the International Maritime Law Moot, and I also participated in the International Air Law Moot and the ALSA Humanitarian Law Moot. And I've written a couple of problems and stuff, so mooting is near and dear to me, and I always relish the opportunity to come back and participate and hear from those who are the up and coming talent in the field, so it's always nice to see that as well.
Just to give a bit of detail about myself, my name's Jonathan Holt. I'm a law graduate here, so not as qualified as Matt. Perhaps what I lack in experience in this firm, I make up for in mooting experience. As Matt has said, I was on the maritime law team. I've done the international insolvency law competition, the Jessup moot, the ALSA championship moot, the Kirby contracts moot, and now the Charrett construction law moot.
This guy.
You can perhaps take it on fairly good authority that when I say that you're all very good mooters, I do mean it. You're now one of the thousands of people that I've seen in mooting competitions, and I'd say you rank very highly up there, particularly, again, as I say, because this is a junior competition. So you all ought to be commended in the highest. And again, I encourage you to continue improving your advocacy wherever you can.
And I would always like to express the thanks to the QUT Law Society for hosting the moot, and it's always great, you know, particularly when the firms, and in this case Cause, can get involved as part of that. By all means, if you ever come across Jonathan and I again in the coming years, if we don't immediately recognise you, please introduce yourselves, remind us where we've seen you before, and it would be a pleasure, of course, to reach out to us with any questions that you might have, or questions about the firm as well. So with that, I hand back to the organisers for some closing remarks, I assume.
Thank you.
Thank you.
Yeah, thank you guys so much. Really detailed feedback you just gave the contestants as well. So yeah, thank you to both of our judges for volunteering their time to help out tonight. And thank you to all of you guys, the contestants here, as well as all of the contestants that are watching the live stream who have participated until this point. And yeah, thank you for Cause Chambers Westgarth for sponsoring the event as well. Yeah, so that's the end of the event. You all did really, really well.
Thank you.
Thank you.
Thank you. Cheers.
Thank you very much.
Thanks,
Cheers.
everyone.
Thank you.